When the Hungarian justice minister walked into that Brussels hearing room, he looked like a man who had done this before. Calm, prepared. Confident that the questions coming his way would be the same ones he had deflected a dozen times already. He had his answers ready. He had his talking points rehearsed. What he didn't have was a response to what MEP Sophie Veld pulled out of her file at the 11-minute mark. And the moment she placed it on the table, everything changed. The hearing was scheduled as a routine rule of law dialogue session. These happen regularly in the European Parliament. A member state sends a minister. MEPs ask questions. The minister explains that everything is fine. The session ends. Nothing moves. Most people watching from the outside never notice. But this session was different before it even began. Because 3 days earlier, a document had surfaced. Not leaked to the press. Not published by an opposition group. Filed directly with the European Parliament Civil Liberties Committee by a serving Hungarian judge who had requested protected status to do so. That document changed the nature of every question asked in that room. It described something specific, not an allegation, not a political grievance, a data discrepancy. A comparison between the official case management records held by Hungary's National Office for the Judiciary and a separate internal audit log that had been maintained by judicial IT staff before that log was deleted from the system. The discrepancy between those two records pointed to one thing. Files had been removed, not archived, not reclassified under a different access tier. Removed. And the removal had occurred in a window of time that directly preceded a series of high-profile verdicts in cases involving individuals connected to the governing network. Veld didn't open with that. She opened with something much simpler. She asked the minister how many judges had left Hungary's court system in the past 3 years. He gave a number. She asked what percentage of those departures were voluntary resignations versus early retirements. He said he didn't have that breakdown available. She said she did, and she read it into the record. The number of early retirements among judges under 50 had increased by 230% since 2021. That is not a natural attrition pattern. That is a signal. In any independent judicial system, that kind of demographic shift among experienced mid-career judges demands an explanation. The minister said it reflected improvements in the pension framework that made early retirement more attractive. Veld looked at him for a moment without speaking. Then she moved to the next question. She asked about the case management system, about the audit logs, about the specific window of time in which the deletions had occurred. The minister said he was not familiar with the technical details of the judiciary's IT infrastructure. Veld said she understood that. She then asked whether he was familiar with the verdicts that had been handed down in the 4 cases whose file records showed the largest discrepancies in the audit comparison. He said he was not in a position to comment on specific judicial decisions. She didn't press that point. She let it sit. And then she moved forward. Because here is the technique that made this exchange so effective. Veld was not building toward a single dramatic revelation. She was building a wall. Brick by brick. Each question added one more layer to a structure that the minister couldn't dismantle because he couldn't engage with the specifics without acknowledging that the specifics existed. And if the specifics existed, the next question became obvious. Why? Why do the audit logs show file deletions? Why did those deletions occur in that particular window? Why do the cases whose records were most affected involve defendants with documented connections to government-linked entities? Why have 230% more mid-career judges retired early since these systems were modified? Why is the Minister of Justice of Hungary sitting in a European Parliament hearing and telling MEPs that he is not familiar with the technical details of his own country's judicial record-keeping? He couldn't answer any of it. So he did what officials do when the factual ground becomes dangerous. He questioned the process. He said the document Veld was referencing had not been verified through official channels. He said the European Parliament should be cautious about relying on materials of uncertain provenance. He said Hungary's judiciary operates independently and that any suggestion of interference was a politically motivated attack on Hungarian sovereignty. Veld let him finish. Then she placed a second document on the table. This one was from the Council of Europe's Venice Commission, an official assessment published 6 months earlier that had raised specific concerns about modifications to Hungary's judicial oversight structures, changes to the appointment process for court presidents, changes to the disciplinary framework for judges. Changes that, taken together, the Venice Commission had described as creating conditions that could undermine judicial independence. This was not a document of uncertain provenance. This was an official finding from one of Europe's most respected legal institutions, and the minister had signed the government's formal response to it. Veld asked him to read the relevant paragraph from that response, the one where the Hungarian government had described the Venice Commission's concerns as based on a fundamental misunderstanding of Hungary's constitutional tradition. He read it. His voice was flat. She asked him whether, given the audit discrepancies now on record, he still stood by that characterization. He said the two matters were unrelated. She said she was interested in how he defined unrelated. He said he didn't think this was a productive line of questioning. She said she agreed that it wasn't productive. And that was precisely the problem. This is what accountability looks like when the institution being held accountable controls its own records. It looks like a hearing where every question is answered with a redirect, where every document is questioned on procedural grounds, where every official finding from an independent body is dismissed as a misunderstanding, where a minister can sit across from a parliamentarian, be presented with audit evidence, Venice Commission findings, and judicial departure statistics, and still manage to leave the room without having answered a single substantive question. It works because it has worked before. Hungary's government has been through rule of law proceedings, Article 7 hearings, funding conditionality battles, and European Court of Justice rulings. It has emerged from all of them intact, not because the concerns were resolved, but because the process moves slowly, and slow processes can be outlasted by governments that have no intention of changing. But something was different about this hearing, because the document filed by the Hungarian judge did not go through the official process. It bypassed the channels that the government monitors and controls. It arrived directly in the hands of MEPs before anyone in Budapest could prepare a response. And once it was in the parliamentary record, the deletion of those court files became part of an official European proceeding, not an allegation circulating in opposition media, an official proceeding. That matters enormously, because it means the question is now permanent. Not just in Hungarian civil society, not just in European press coverage, but in the formal institutional record of the European Parliament. Which means every time Hungary's government presents itself to European institutions going forward, that record is there. Those questions are there. And the answers that were never given are there too, documented as absences. The minister left the room the way he came in, composed, unhurried, his talking points intact. But the hearing had produced something his talking points could not address, a comparison between what the official record showed and what the audit log showed before they were deleted, between what the Venice Commission found and what the government said it found, between the number of judges who have left and the number of cases that went a particular way. Comparisons don't disappear when a minister leaves the room. They stay. They accumulate. And eventually, the distance between what is said and what is documented becomes too wide for any institutional deflection to bridge. Veld submitted the full dossier for formal inclusion in the committee record. The minister's non-answers were transcribed verbatim. The audit comparison, the Venice Commission paragraph, the judicial departure statistics, all of it is now part of what Brussels knows about what Budapest has been doing with its court files. The hearing ended. The cameras moved on. But the record is still open, and the files that were deleted from a server in Budapest still show up as absences in a log that a judge risked their career to preserve. That judge understood something important, that in a system designed to make accountability impossible, the most powerful thing you can do is make sure the evidence exists somewhere it cannot be reached. It exists now, and no amount of sovereign rhetoric can delete it a second time.